The word of the day is impeachment. We've got a whole thing going on in our country now over what impeachment is and what it means, and I am here to provide you with a tight, concise summary of constitutional impeachment using the only Supreme Court case that matters about how impeachment occurs and is conducted, and that is Nixon versus the United States. No, not that Nixon, a different Nixon in the early 90s. Let's take a look at it, and let's take a look at how that impacts the current questions around the impeachment of President Donald Trump. Hey, what's up, guys? My name's Rekieta. I'm a small-town lawyer in central Minnesota, and this is my show, Lawsplaining the Interwebs. If you're new to the channel, click like, click subscribe. These videos are sort of 10, 15-minute summaries on hopefully complex legal questions that I can distill down and make very digestible, so you don't have to spend $100,000 listening to a bunch of morons for several years at a law school, okay? You just get to listen to one moron for 10 minutes on one issue, and that's me. If you like that, click like and subscribe, and then also we do live streams like every weeknight at 11 p.m. Central. Come check those out as well. Way different, but lots of fun. Let's get into this. Right now, it's December 21st, 2019, and President Donald Trump was recently voted in the House to be impeached, the House of Representatives. The House of Representatives has the sole power to bring impeachment against an official, including the President of the United States. No one gets to question the House's ability to do that. The Judicial Branch doesn't get to review that. The President can complain, but that's what happens. Is the House has the sole authority to do that. But that doesn't actually do anything operative until it goes to the Senate, and then the Senate has tries the impeachment and then votes on it. And if they vote by a 2/3 majority to remove the president or other official, then they're gone. Then they're removed. Simple as that, right? I mean, sort of, but that's a bigger discussion. Anyway, that's how the impeachment process works. And similar to how no one gets to question the House's ability to bring the impeachment, no one gets to question the Senate's ability to try the impeachment. And we had a case about this in the early 90s, and it was Nixon versus the United States. It was not President Nixon. In this case, it was a federal district court judge with the same last name, Nixon, right? This guy ends up getting convicted for lying under oath to a grand jury, and he goes to prison. But while in prison, he doesn't resign as judge, and he just sits in prison collecting his income and maintaining his benefits, healthcare, and all of that stuff that are conferred upon district court judges. He's like, no, it's cool. I'm going to just keep getting money from you. Finally, they realized that this was probably not the correct solution, so the House initiated impeachment proceedings against him. They voted to impeach him. I mean, this guy is convicted of crimes. He's sitting literally in prison. So they vote to impeach him and remove him from office. They communicate that impeachment to the Senate, and then the Senate holds a hearing. But now when they held the hearing, it was just in front of the Senate Judiciary Committee. Now, the Senate Judiciary Committee did their hearing trial sort of thing. They took witness testimony and all of that stuff, and then they voted to move forward with the impeachment. That moves it to the regular Senate, just like a normal bill would come out of committee and then go to the Senate floor for a vote. The Senate floor had a 3-hour discussion about it, and they decided, yeah, this guy needs to go. So they voted by a 2/3 supermajority, actually by more than that, to go ahead and remove this guy from his federal judgeship. He actually brought this to the Supreme Court, suing the Senate, saying he was entitled to more process than that. He was entitled to actually a full trial in front of the full Senate. Now, the judiciary, the Supreme Court and the Judicial Branch, they came together and decided that the Supreme Court doesn't actually get to review how the Senate does its impeachment proceedings, except for some very limited circumstances which were not present here. Okay, let's take a look at how they did that It's in here, and it's part of a greater political, a greater doctrine called the political question doctrine, which comes out of a case called Baker v. Carr. We're not going to go through Baker v. Carr because it's much broader than this, but in the narrow sense, it basically says that the Constitution is precise on 3 points of how the Senate conducts its hearing, and it's imprecise on the rest, but it gives all of the power to do it to the Senate. So since it's imprecise and gives all of the power to the Senate, the judicial branch doesn't have any grounds to go ahead and say they did it wrong. The Senate gets to make up its rules. Here's the text. In this case, we must examine Article 1, Section 3, Clause 6 to determine the scope of authority conferred upon the Senate by the framers regarding impeachment. It provides, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. And no person shall be convicted without the concurrence of 2/3 of the members present. That's it. That's all they get. That's all of the instructions that the Senate has from the Constitution. Now let's see what the court did with that. The language and structure of this clause are revealing. The first sentence is a grant of authority to the Senate, and the word sole indicates that this authority is reposed in the Senate and nowhere else. The next two sentences specify requirements to which the Senate proceedings shall conform. The Senate shall be on oath or affirmation, a 2/3 vote is required to convict, and when the President is tried, the Chief Justice shall preside. Now, the court doesn't actually get to those three things because those three things aren't at issue in the case that was in front of them, but they imply throughout the rest of the ruling that should the Senate exceed or omit any of those three things, that might actually be reviewable by the Supreme Court. So if the Senate wasn't on, or if the senators weren't on oath or affirmation when they did the hearing and the vote, then sure, the Supreme Court could review that. But other than those three limiting factors, the Supreme Court is not going to get involved and not review it. Okay, there's the next part of this is over that word try. What does it mean to try it? And this was Nixon's biggest complaint, right? He said he didn't get enough of a trial because he was only in front of the Judiciary Committee, not the whole Senate. But let's see how the Supreme Court looked at that. The conclusion that the use of the word try in the first sentence of the impeachment trial clause lacks sufficient precision to afford any judicially manageable standard of review to the Senate's actions is fortified by the existence of three very specific requirements the Constitution does impose on the Senate when trying impeachments. The members must be under oath, a 2/3 vote is required to convict, and the Chief Justice presides when the President is tried. These limitations are quite precise, and their nature suggests that the framers did not intend to impose additional limitations on the form of the Senate proceedings by the use of the word try in the first sentence. So that was a longer, more legalized, legalistic, boring way of saying what I was saying. It's very simple. Since the framers did not precisely lay out the manner that the impeachment proceedings will occur, but also gave sole authority to the Senate to do it, nobody gets to come in and question how the Senate does it. So that actually means the Senate can kind of get together, try the case, and just have a vote. And they could do this all in 10, 20 minutes if they want. If they know the conclusion, they can do it, so long as they follow those three specific things. Now, government never does anything in 10 minutes, so it's probably not going to happen that way. Plus, you'll have the Chief Justice presiding over the hearing. So he'll have some structure that he'll add to it, but the Senate makes all of the rules. And technically, the Senate could pass rules to change or limit the way the Chief Justice handles the hearing. But the Senate has the unquestioned authority to do it. So the main conclusion of this video is when you see these guys out there commenting about, can they bring these articles of impeachment against Trump? Are they valid? Yes, they're valid because the House has the sole authority to do it. And by implication of this case, the Supreme Court can't review the House's decision on what is and isn't impeachable. Just can't really do it. There's not precise enough language to say so. Whatever they say is a high crime or misdemeanor or bribery or treason, that is, for the purposes of impeachment, those things, but only for the purposes of impeachment. A criminal trial on any of those things would be completely different. And that's part of why the judiciary isn't allowed to intervene in the congressional aspect of it, because there's a separation there between the political and the criminal. Right? The political stuff is done by the political branch, the legislative branch, which is the House and the Senate. The criminal stuff would be handled by the judiciary if there were criminal stuff. But those are separate questions. So then the question moves. How does the Senate have to do this? Is there some invalid way to the Senate could conduct the hearing? As long as the Senate does what is specifically stated, being on oath or affirmation, 2/3 majority vote to convict on the impeachment, and then finally, in the case that the president is the one impeached, the Supreme Court Chief Justice presides over the hearing. That's it. As long as they do those three things, nothing else matters. No one gets a say in anything else. Whatever conclusion they come to sticks, period. There is no review. The framers didn't want it. The case is really interesting. I'd encourage you to read it. It's Nixon versus United States. I believe it was 1991 or 93, early 90s anyway. And you can read all about where the framers talked about this stuff. But this video is supposed to be just about 10 minutes long and really hammer home on the points. So hopefully I've done that. Hopefully this is something you like to see and you learn a little bit about something really, really important going on right now that a bunch of really, really smart and qualified people are making very definitive statements about that they cannot make. They just can't do it because no one gets to question how the House handles it. No one gets to question how the Senate handles it. They'll handle it how they do outside of the very minimal requirements that are laid out in the Constitution. Everything else is up for grabs, and we get to argue and scream at each other about it all we want, but in the end, it's ultimately a political question, which ultimately removes the justices of the Supreme Court from hearing about it. So there you go, guys. Go out armed to yell at people on Facebook and Twitter about this. It's super fun, and I hope you enjoyed this and had a great, great time. Come back. Peace. Peace.